Hey everyone. I hope everyone is doing really well. I wanted to reconnect because I did tell everyone last night that I would do some follow up after reviewing the entire bill and that I would bring forward some of the areas that, there's a lot of areas we like, but some of the areas of concern and suggested changes that we're looking to make. So we put a briefing together that I'm going to put on the screen so we can take a look at it together. So let me just bring that up really quick. Okay. Screen share. Okay. So you guys should be able to see that now. Perfect. I'm going to try to make it a little bit bigger for you so that way everyone can see what we're looking at. So for the I Am Vanessa Guillen Act, we finished reading it and we put this piece together for the community so you can understand better what the legislation says and some of the suggested changes we're looking at. Sections 1 and 2 were about the reporting process as well as having a special prosecutor outside of the chain of command. And if someone has gone through sexual violence, that their chain of command cannot issue a court martial or anything like that against them. Section 3, this was where the first area of concern came up for us. And I had mentioned this yesterday. So under Section 3, it talks about the punitive article on sexual harassment and related investigative matters. So specifically under these clause for sexual harassment, in the subsection actions of complaints alleging sexual harassment, the current language in the bill specifically refers to sexual orientation and protected characteristics such as sex and race. So for here, this was something that we are going to be advocating for tomorrow, that the language also includes gender identity. So whether it's sexual orientation and or gender identity, and also under protected characteristics, to put sex, gender identity, and race to ensure that, transgender veterans are protected. Because the reality is, if someone's transgender and they go through MST, they could be discharged with gender dysmorphia. And we've seen that happen in our community. We have community members that have gone through that. So it's really just making sure that there's as broad language and inclusivity in what a protected class is, because someone who is transgender who can get a retaliatory discharge based on gender identity for gender dysmorphia when they report military sexual trauma still leaves that class of veterans very vulnerable. So a simple language change to include gender identity can resolve that in this legal standard. So that's something that we're looking to do to make sure that it's a little more inclusive. Then when we go to Section 3, subsection A, right? Subsection A. The current language is armed forces shall, as soon as practical, after such receipt, forward the complaint to an independent investigator. So this was something we spoke with Jackie Spears' office at length about. And what I thought was interesting is, while they implemented our suggestion for the timeframes for the independent investigator to initiate an investigation within 72 hours, they didn't put that standard for the person who's receiving the initial complaint. So what we put in here under suggested language was that, all members of the armed forces who receive a complaint, as soon as practical, but no later than 72 hours after such receipt, will have to forward it to an independent investigator. In the event that the complaint is submitted after the 72 hours, a reasonable exception may apply, meaning that if you submit it afterwards, you have to get permission from, whoever is the next person in line saying why it was submitted late. And there might be a reasonable explanation, but if there's not, failure to forward the complaint with no exception will result in disciplinary action. The reason for that is to make sure that chains of command who are receiving the complaints are not trying to hide the complaint itself, right? So if they are and they didn't get an approval to delay for it to be delayed and it's not handed in, obviously it looks like some hiding is going on, and that's an issue that can further harm service members. So having it in there of like they get it and they have 72 hours to forward it to an investigator, and then the investigator has 72 hours to begin and initiate a complaint. So what that means is no later than 6 days after the complaint, it's already on file and it's already starting an investigation at that point, within less than a week. That's the idea. The ideal situation would be on day one. As soon as someone reports, the chain of command turns it over to an investigator at the same time, on the same day, and then the investigator can start getting the paperwork ready. And with day number 2 in 24 to 48 hours, an investigation's already starting. That would be the ideal circumstance. And then the worst case scenario would be 6 days in total from when the complaint happens to when an investigation starts. So, and that also helps to prevent corruption and hiding. And the sooner the complaint gets forwarded, the less likely someone's going to try to do something that's retaliation or something to intimidate the service member to stop them from reporting. So that is one of the areas that we're looking for a change. Another area is under the definition of what a formal complaint is. Right now, a formal complaint is defined in writing and attests to the accuracy of the information in the complaint. Expanding that, a formal complaint should include the definition of an oral complaint as well. Oral complaints should trigger a written complaint by the receiving member. Trigger words such as rape, sexual violence, harassment, stalking are words that should trigger the process of an oral complaint moving towards formalizing it. By expanding that definition, you allow people who don't necessarily want to report and I don't know for sure if we're allowed to send the bill. I mean, I don't see why not, but I'll ask tomorrow. I could, if you want our particular slide on the changes that we're suggesting, I could totally email that to you. So if that's something you're interested in, just let us know. In terms of the, in terms of the complaint processing and the oral complaints, the broader definition will be helpful. Obviously, it allows someone who does an oral complaint to go down the formalized process because the rules as they're stated, like the 72-hour window, the protections that are under that rule are for formal complaints. So if someone does an oral complaint right now and it never gets formalized, none of these rules apply. So, having an oral complaint come in and having someone be able to convert it into a formal complaint, that option should be there. And formal complaints should be triggered in certain cases in order to have that happen. While there is confidential reporting, and the confidential reporting can be taken in by someone else, these complaints should all be formalized at some point. For confidential reporting, this is reporting to the House Armed Services Committee and the Senate Armed Forces Committee reporting. So this was something that we also had a discussion with them about, that ultimately the committees, the House and Senate Armed Forces Committee, should be receiving reports with the data of what's happening in order to start beginning to see trends, where they're coming from, and how to be able to mitigate risk by creating different regulations that can prevent whatever cluster is happening at a certain time. So one of the things that they did implement was an annual report going to the committees containing this information. We're advocating for a quarterly report as well as an annual report. The reason for that is that quarterly reports are trends that happen over 3-month periods, over 12 weeks. And generally, when you're getting a quarterly report, you can see intra-quarter certain trends that were emerging at certain times. And that allows for better data and problem solving. Because if you have 2 quarters, for instance, let's say maybe around 4th of July, so third quarter, and maybe around Christmas, fourth quarter, maybe that's where most of this is happening. And we're seeing certain dates emerge. That allows a more detailed sense of feedback than what an annual report would give, because an annual report is just going to give everything that's happened throughout the year. And yes, you might see some spikes in certain cases, but by the time you get the annual report, you're on to the next year and the trends might look different. Where quarterly reporting too, when you do look at it on a year-to-year basis, you can look at Q3 of 2020, Q3 of 2021, and you can also start navigating when these trends happen the most in order to make policies that are specific to resolving them. And also the quarterly reporting allows for intra-year changes to be made. If you're only getting an annual report, you have to base it off of annual data, and there's no intra-year changes that can be made as a result because you're only getting annual reporting. So the quarterly reporting could help save lives, because when you're doing an intra-year change that could be made based on that quarterly data, it's more rapid response. And if there's certain trends that are emerging, they would be, the committees would be able to identify it right away and discuss with the proper channels how to resolve those problems intra-year. And then the remaining quarters would reflect those changes. And, depending on whether they were successful or not, the remainder of the quarters would then say whether, this rule or this policy or regulation should go for the long term. So that's on that part. Okay, now I'm going to get to Section 5, the authorization of claims by service members against the United States that arise from sex-related offenses. So everyone knows about the FAIRS doctrine. You can't sue the government if you've been raped while serving, because they considered it an on-the-job thing, even though it shouldn't be. So under the I Am Vanessa Guillen bill, there is the ability to sue and put in a claim against the department. The way the current language under requirements for the claim, a claim is presented to the department in writing within 2 years after the claim accrues. The issue with this, there's a couple issues. So one of the things is a claim that is presented through the department within writing after 2 years. The suggested language we put is with the exception of those who experienced MST prior to the enactment of this law. Retroactive claims may be submitted under this law that have exceeded the 2-year claim reporting timeline. That would allow retroactive claims to be pursued for people who have gone through this in the past, who obviously have dealt with a lot of the trauma behind this. And, people deserve to get justice for what they've gone through, versus only people in the future can file a claim on this. Because remember, there is 1.5 million service members that have experienced military sexual trauma and that are suffering. So there's that injustice needs to be corrected, as well as for the future. So hopefully this is something that they'll entertain, where, a retroactive claims process for service members who've already, gone through MST, have been out prior to this law getting put into place. That itself is something where we would like to see. There is an area of concern with the way that it's being put together. So civil claims on average take 2 to 4 years to complete. A veteran who's experienced military sexual trauma is most likely to commit suicide in years 1 through 3 after experiencing military sexual trauma. So this was where we spoke about the arbitration panel and an arbitration board. With an arbitration panel and a founded claim, a disciplinary action from the DOD would be a payment to the victim directly after the investigation is complete and founded. So with that process, that basically means the survivor would get money without having to go to court. And the other thing is, there's a clause in this bill about going to court that specifically states if a service member goes to court and just does a dispute, the issue is legal fees are not covered under the law. Like, there's an exception that says you can sue, but we're not covering your legal fees. An attorney can sign on, but they can't charge you more than 20%. So the number they're using in the bill is like above or below is 100 grand. What that means is that you'd have to file a civil case and filing fees. So you're looking at the attorney. If you get an award for 100 grand, it's going to take you 2 to 4 years to go to start to finish, unless the military settles, right? If it goes to your case goes to litigation, 2 to 4 years. Then on top of that, the attorney can take 20% of your award because the U.S. government is not paying out attorney's fees. So there's a specific clause in there that says it. However, they can take up to 20% from your award that you receive for your legal fees. Next thing is that when that happens, you also have to pay the legal fees out of there too. So you're probably looking at about 25% of the overall cost is going to legal costs plus the attorney. So now if you had 100 grand, you're at 75,000, and that's going to take you years to get to that point. And when that happens, you're looking at, after years of fighting, years of being re-victimized, because now you have to go through the legal process for this. So in order to get and win the claim, so that's something else that we're looking at, because if they move it over as just a disciplinary action, you don't have to get a judge involved, you don't have to get a lawyer involved, do the filing fees. If the claim is founded and they issue it as a fine, right, and into a victims fund, I think that would do better for everyone who's involved, where we have 401ks, we have all these special types of accounts. So I'll bring the screen back up so you can see what I want to look at for tomorrow. Am I still on the screen share? Hold on. Okay. Make it bigger. One of the things that also I think needs to be a consideration is many survivors of military sexual trauma will have substance abuse issues, and there should be the establishment of a victims emergency fund that can be administered under TSP. The account should be tax-free, as well as earnings on the investments should remain tax-free as well. This rule regarding withdrawal should be for purchasing a home, a car, clothing for work, food, rent, medical treatment, fertility treatment, and other necessities, to ensure the money is being used to stabilize the survivor and provide them with a sense of well-being. That's really the ending of like, ooh. Here we go. So those are the main areas of concern in the bill. And, in terms of like money management skills, that's a big skill. And if someone's dealing with substance abuse, they might not stabilize themselves with that money or the earnings that they got for going through that trauma. The other issue is like survivors may not survive to fight in litigation. So if the point is to like rectify the damages to help the victim stabilize their life, I think there's some holes in there that could be harmful. Like me going through that at 18 years old, like I came out like on drugs, So it's like, thank God I've had enough rationale to like make some good choices, but that's not going to happen for everyone. So, having like a special account type and being able to have certain rules with how that account works, make sure that people are using the money in a way that benefits and enhances their lives, so survivors can recover and be functional. And I think that that's very important. Also, I think in terms of the um, bill itself, it's like, you know, a lot of the money, at least 25% of the money that you'd get awarded is going to get eroded to legal fees and attorney's costs. So, like, on that aspect of it, I think if they can somehow move it under like a disciplinary fine and put it into like a special victims fund, and administer the money from there, I think that that would be a lot better. I just don't know based on the bill whether that's something that's feasible at this point. But that's something that I would definitely want to bring up in a conversation tomorrow. Lastly, there's two studies that are called for in the act. One of them is the study of Sharp, right? So at this point, there's nothing dismantling Sharp. This bill just calls for a study on Sharp and essentially what each individual organization's doing. And then there's going to be two independent audits on it that are going to be done in order to make sure that they're complying with standards. Let me pull this up. I'm just gonna go to the fact sheet for this one versus like reading all those pages. Um, here you go. So for the SHARP program, it's going to require the Department of Defense and the Government Accountability Office to conduct two separate reviews of the military sexual harassment and assault response programs within 180 days of enactment of the bill. So the DoD has to evaluate alternative structures for SHARP. I think what they were doing with this is for MIRA, the way we did the structure for the regulatory authority was that there would be universal training across the board amongst all branches, all leadership at all levels. So this looks like this is becoming the prerequisite to that because part of the bill speaks about uniformity amongst the branches for education, prevention, licensing, continuing education, and responses. And yeah, I mean, I honestly feel like everyone definitely has that consensus. So when we initially submitted the MIRA bill to Congress, that we spoke about that specifically surrounding MIRA and, you know, the licensing, the auditing, and such, right? But what it looks like they're doing within this bill is that it looks like we're going to get what we want, but this bill is going to be the precursor to moving in the direction that everyone wants. Because they're doing section 6 is essentially studying SHARP. The DoD is required to evaluate alternative structures for SHARP, that's what we gave in alternative structure for SHARP is MIRA. So they have to evaluate alternative structures for SHARP, including using civilians, contractors, service members, and dedicated personnel to the specialty, as well as the Secretary of Defense to consider what's going to be the most appropriate course of action moving forward. So it looks like SHARP is not going to get dismantled until these studies are all complete. But if they, if they reflect on private sector regulation, so generally each field has, like Wall Street, FINRA and the SEC create universal standards. So whether I would work at JP Morgan, Citi, or Bank of America, my licenses were all held through FINRA and the SEC. So no matter who I worked for, I had the same rules and standards for my training, for my licensing, for my continuing education, for my auditing. Everything was hubbed in a third-party regulatory body. So no matter what firm I went to, I was upheld to the same exact standard. So the reason I think that they're doing that is because it's not set up like that right now. And that is the main talking point that we had with Congress, that, you have to be able to have uniform standards across the board at all levels, in all branches. There needs to be uniformity in the training, the standards, how they're getting done, because if someone's falling short in a certain area and they're not meeting universal standards across the board, you're most likely going to have more reports of sexual assault. And the best metric for doing that is putting everyone on the same standards, the same regulations, the same training program, because if you see that all of these branches are doing great, all of these chains of command are doing great, and then you go in and this one chain of command is just not with it, you know that there's issues within that leadership chain specifically, because within the rest of the industry, standards are being upheld. And they use that a lot in finance to determine in like in the finance news, and it's like um, Goldman Sachs was involved in X, Y, and Z, or JP Morgan's traders were in this cahoots. And it's because there's universal standards across the industry. So when people are getting together to start violating that, it's easy to figure out who it is and where it's coming from. And, then you could dial in on making the corrections. It's hard if you have, different sexual assault response programs, different standards, different people, who are doing that. No course of testing or auditing or continuing education. It's really hard to get the data you need to understand where the problems are arising from, where uniformity helps to protect that. So this looks like this is going to be the beginning phases of that. They're also looking to assess the impacts and the efficiency of the SHARP program, and then make recommendations how to improve these programs. So that sounds like eventually it's going to evolve. Honestly, I think they should dissolve SHARP altogether. And instead of giving each individual branch funding for their SHARP program, it's administered directly through the Department of Defense. Funding stays within Department of Defense, and the Department of Defense divvies out the correspondence, the everything that they need for the training. And so that way there's always uniformity in the standards, the training that's being issued, that's coming out, and all of that. There's also going to be a study of members absent without leave or unauthorized absence, which I do think is great. And I'm almost surprised that this has never been done. So GOA is going to conduct a study by the U.S. military departments to respond to missing service members and make recommendations to improve these procedures. The GAO review would require to cover military service guidelines for distinguishing between common cases and cases that might involve foul play in which a service member might be in danger. Guidelines for cooperation between the military and other law enforcement agencies, such as the use of social and traditional media in conjunction with other cases, military resources available for such cases, and any shortfalls in the resources. How the procedures would be used would vary by law and law enforcement agencies, and best practices for responding to and investigating such cases. So it looks like they're going to be doing studies on the service members who are going absent without leave. So like that would be someone like me who did that, and my study or like reason would be because of sexual violence and being denied reporting and then going through hazing for trying to report. So I mean, fear for my life, that would be the reason, but they're going to start conducting studies on this, which I find crazy because so many people have gone UA over the 100 years that the military's been. And whenever you have heard someone's story about going UA, it's always something related to trauma. It's always something related to trauma. Let me see some questions we have. What part of it would you want transition to civilian employers? Because there are systems of a recourse in civilian law that don't exist in military law. Like you can sue your boss and your firm for sexual harassment. Like that's legal in the civilian world. Right now in the military, it's not, but this bill would allow that. Also, recourse and reporting. If something happens in your place of employment, you don't have to worry about going to you can go to your HR, you can go to your boss. However, you also have the right to go to the police, and your legal system is not together. It's separated in the civilian world, where in the military world, it's all together. The legal system, your chain of commands. So if you go through sexual violence within your chain of command and then you're reporting to them, you're getting retaliated against. That's just what's going to happen. But if you want to explain that a little more, I'm more than happy to better understand your question. I'm not familiar with SHARP. SHARP is the sexual harassment assault response program. Sexual harassment assault response program. And that's the other thing too that we put in there was like, in this bill, it talks a lot about response, right? Like how to respond to sexual assault, how to respond. They also need to move over that training into prevention. What do we do to prevent sexual assault? And that needs to be a focal point as well, because like the training, the continuing education needs to show both sides. We need to prevent sexual assault. Here's why. When sexual assault happens, here's what happens. Here's what it does to our reputation. Here's what it does to the military. Here's what it does to service members. Here's what happens to veterans. Here's what happens to the community when we don't properly address this or when we fall short of our standards. So I think in that aspect, that's something that definitely does need to get addressed. And I think prevention is something that needs to be spoken more about that I'd love to see in this bill. So this is something I've heard so many times, and that was why we put as much as we did into MIRA in terms of like training, education, continuing ed, licensing. A lot of different aspects of that are in this bill, which I think is great, and I'm happy that Congress is listening to what we're saying and suggesting. The only thing is with some of it, even though the ideas are in there, these studies have to happen. So they're not getting implemented right away, even though that's what I would like. But I do think what's going to happen is these studies are going to move the conversation in a direction where a lot of the stuff that is being spoken about in the bill and what we suggested is going to manifest. So I do think SHARP is going to go bye-bye. And I do think what's going to happen is some form of MIRA is going to get erected to, regulate training and auditing and licensing and processes and things like that. That's honestly what I see happening here, just based on where we are in the process with the bill. That's fine that people want to stop military sexual assault. But when other people are getting bullied and sexually assaulted over the internet, who are supposed to be people standing up for these things? That's what makes people not believe anymore. So what I would say to that is there's always going to be dissent. There's always going to be people that will say things that are hurtful. That's human nature. In terms of like fighting the good fight, stay the course, stay the course for what matters and what you believe in. But like, from telling my personal story to doing advocacy work, like it's at this point, there's an everyday thing that I hear about myself on the internet or I see someone post or whatever. And the reality of it is it's a waste of time, right? Like these people are a waste of energy. So it's like when you're doing advocacy work, focus on what you have to focus on what matters. And, when these issues do come up, decide whether it's an issue that needs your attention or not. In certain cases, there are reasons why you'll take an action or respond, but you got to pick and choose. Otherwise, you'll get so distracted from what you're doing that you start losing sight of the cause. So, you don't want to do that. You always want to stay on focus and, do what you need to do, regardless of what other people are doing or saying. The best thing I could say is be like Teflon. They say something and just ignore it. Like, let it bounce back to them and let them feel their feelings. From the veterans prospect, we need to have more advocating to protect more existing survivors continue to suffer at. Seems like on the military we need to take. So I know that the VA does have a legal process that you can sue. That got changed last year. In terms of civilian employers, there is a right in the civilian world. If you go through sexual harassment at work, you have recourse to file a civil claim and a criminal claim. It's already designed into the system if you're going through that with an employer. So you have the recourse to file a criminal complaint where you are or where you work, and you can do the same thing with civil court. I'm not sure if that's what you mean, but that is available. In terms of getting, justice or monetary compensation for going through MST and then like our lives being fucked as a result, what I would say to that is the bill is covering like future cases. So one of the things that I'd like to talk to Congress about tomorrow is going to be, what about retroactive payments to people who've already dealt with MST, who already have it, and they were never able to sue because of the Ferris Doctrine. So that 2-year time frame, I'm interested in having an exception policy and a retroactive exception for people who've already gone through it, because like I went through it 12 years ago. However, in my life, with the amount of relapses I've had, it is something that's been damaging to my life. So, there's so many of us in that situation that I think retroactive filing should be done. Whether or not it'll get implemented, I'm not going to know that until tomorrow's conversation. So when I do find out what direction that goes in, I'll definitely let you know. So that's for that part. Like I said, the studies are going in for Sharp. And I really think that's going to get, I have a strong feeling Sharp is going to get dismantled and all the MIRA policies are going to get put in under Sharp. So that's for that part. A lot of other policies and stuff that we suggested are in there already for changes. And I think that those are good. It's just more like, it was a little bit of like, okay, you're adding diversity, but like not as diverse as we were interested in, right? So it was like, let's be a little more diverse. Or, yes, the time frame was great for the investigator, but we need that also for the person taking on the complaint. So I think those are more little adjustments to smooth line the process, or like expanding what a formal complaint looks like. That's really some of the adjustments to the talking pieces that we already did, but I did think they did a good job transcribing what we suggested, how they put it together and everything. I think, Jackie Spears staffers did a really great job on that forefront. And now it'll be, how do we get these little extra, pieces in there to really make this the bill that it needs to be. But happy to see the direction with it. This is definitely an improvement from, what we had. We didn't really have anything going on before. So I think this is going to be in a good direction. Thank you so much. I really do appreciate that feedback, we'll definitely give you an idea of how it goes. Sometimes they don't tell you anything right away. It's like you get an email later, but we could do a little debrief tomorrow after the meeting for sure. And I appreciate sending me good vibes. We need that so we could be able to have these healthy conversations tomorrow. So totally appreciate that. So I know the compact bill, which is a different bill from this one, is looking to move to give all veterans, regardless of discharge, benefits at the VA. So like you'll be able to access the VA for healthcare no matter what. In terms of the ability to file a claim, there's in the bill, let me just go to that part of the bill, because in terms of, I don't think it said anything about discharge. It was just more like time frame and some other things, but I can read you the requirements. There you go, filing claims. I want to keep this organized. All right, filing claims, so I can answer this question. Regulations. Okay, here we go. Under regulations. I don't see anywhere on here where it says anything about discharge or not being able to put in, but I'm going to read this to you, and then maybe you might have a question about it, but I don't see anything in this bill that says anything about discharge. So the requirement for claims: a claim may be allowed, settled, paid under the subsection A only if the claim is filed by the claimant who is the victim of the sex-related offense, or by an authorized representative on behalf of a claimant who last page 20, here we go. Who is deceased or otherwise unable to file a claim due to incapacitation. The claimant was a member of the armed forces under jurisdiction of the Secretary of the Military Department at the time the sex-related offense occurred. 3, the claimant must present to the department in writing within 2 years after the claim accrues. The claim is not allowed to be settled or paid under any other provision of law. The claim is substantiated as prescribed in the regulation by the Secretary of Defense in the subsection. That's what it says are the requirements for a claim. It doesn't say anything on here that a discharge prevents from putting in a claim. There's nothing in here, and I've read this now like 10 times, and I didn't see anything like that. I know under the compact bill that went through, that was like a different project. The compact bill that was related to the VA, and the VA is putting in new rules that no matter what your discharge is, you can access benefits at the VA. However, I think it's only medical right now. I don't know if they're going to be doing schooling and housing and other benefits like that. I'm unsure. I do have to review the compact bill, and that is something that I have to look at also. But I got to take care of tomorrow's meeting first. So that's all I see for there. I don't see anywhere where it's going to deny somebody, with BCD or anything else, the ability to file a claim. Aw. I mean, listen, I'm happy to be able to do this and to be a part of it. Like, it was such a crazy roller coaster story on how this manifested and how we got here. And to be in this position now, like, this is the moment, and this is the moment for us. This is the moment for our community, and this is the moment for everyone, because the thing about it is Vanessa's story it's a story so many of us have gone through, to the extent we survived, and not everyone does. And that's something we have known. So to be at a point of learning about what was going on, to getting involved in the activism, but like still doing our thing, right? Like still rocking with our policies, but getting involved in the cause to find Vanessa and keep moving the movement forward, to then get to this point that like now a lot of Mira is becoming the I Am Vanessa Guillen bill. It is a humbling experience. I'm thankful for it because, I like in my heart, I was always like, no, we're getting Mira passed. These laws have to get passed. Like, these policies are great. They have to get passed. Change needs to happen. So what we did was, over the summer, we went from changing our strategy to doing in-person advocacy to remote advocacy, because the thing was, nobody was at Congress all summer. And even going into session now, none of them are there. Like, their staffers aren't there. No one's there. So it's like you can't do traditional lobbying that we would normally do in the past, or like what we did last September when we first, did a sit-in at Senator McSally's house, her office at the Russell Building. And we lobbied her office. We built relationships with them, started meeting with them. And then, we started doing that with different offices throughout the country. And then we finally got to the committees. And then at that point that we got to the committees and their staffers, we had to do everything remotely. And that also changed the way our lobbying kits looked, like dramatically, because we had to make digital kits that would be easy to understand, because we're not sitting right there in a face-to-face meeting. It's we're doing it digitally, just like this, right? And it's like we're having these meetings. There's a certain amount of time that there's available in these meetings, and then we're trying to, like, here's the facts, here's the statistics, this is why this is a good solution, and you're throwing out so many things that we had to create specific digital interactive lobbying kits where, members of Congress and their staffers would be able to really understand the policies that we were putting forth and why they were needed. Now, to see those policies while we were going forward with Mira and doing our lobbying, because that's what we were doing since last year anyway, we just kept on with Mira the whole time. And what's really crazy about it is when we kept taking on these meetings, when we kept taking these meetings on, we were just going forward with the game plan we always had, that like these are the policies that we want, that we're supporting, and we want to see these changes. So then when we were working with the committees, they did ask how we felt about our policies, be going in honor of Vanessa Guillen. And they did tell us that, but the thing is, like, whether or not that was going to happen, I wasn't sure on, you know what I mean? And I didn't know, because like we were lobbying for Mira and the policies for Mira. However, did I want it to be a part of this? Absolutely. Did I know it was going to be a part of this? No, I didn't, because, ultimately there's other people involved in this process. So we were really just putting our best foot forward of like, these are the reforms we know we need, that are coming from the community. And, we're very inclusive. We consider everyone whenever we're doing bills and legislation. And, we look at equality, we look at the metrics for progress, protection for the next generation. There are certain metrics that we hit when we're looking at how to create a solution. So we didn't know what was going to happen, but we knew, based on our conversations, that like change was happening, because we kept attending meetings with the committees and their staffers. And we kept, emailing and phone calls, and like all summer, we basically had done e-lobbying, like digital lobbying. And that's where we were at all summer, was meeting after meeting with office after office about how do we do this? How do we create change? So then when we were meeting with Jackie Spears' office and her staffers, and we were going over Mira and explaining it to them, that was when they brought to us, like, how would you feel about this legislation being in honor of Vanessa Guillen? And I was like, yeah, like that. I think that that's the best legacy that we could, as an organization, leave, is make this contribution with our policies, because our policies are solid. They are very, very solid, strong policies that will make a difference. And like, even in what I showed you, like a lot of what I showed you that I went over for revision purposes are our policies that we suggested. It's just they need a little tweak here or there, right? Like, the inclusivity for sexuality and race, like we want gender identity in there. That's what we suggested to Congress from the beginning, that we want that to be inclusive. And then in terms of the timelines for reporting, the mandates when they need to be reported, and that has to get done by, to prevent corruption, that was something we brought to Congress. They put half of it in one, so I don't see why it's going to be a problem to add it to the other piece. But, a lot of the really strong policies where we had concerns that corruption could potentially get in, they are being addressed in the bill. And a lot of those policies came from our Mira doc, the Mira legislation we created. So it's nice to see our work now in the I Am Vanessa Guillen bill. Like, it's a dream come true. And the reason why I say that is, like, I think about this for myself, and like, at the end of the day, like, I'm a Puerto Rican woman. I grew up in a Spanish speaking household. I grew up in the culture. And even though like I grew up in a white community with white sounding friends, and I look and sound white, the culture itself is very tied to who I am and my values, and knowing that I am a minority, and even though I'm a minority and I'm white looking, I know that I have white privilege, but I also know the storyline behind what it means to be a minority and how much disenfranchisement happens. So it's like, when our artist, she lives in Houston, Texas, she brought this story to me while it was still a local story. And when I read what happened and that she was missing, I was like, she's either UA or she's dead. And I was like, she went through sexual violence and it's one of these two. But I was like, we have to find this girl. And when I was talking to our movement artist, we were working on other projects. And when we were doing that, um, she kept like giving me updates from Texas. And every time an article came out from Texas, we were posting it on the movement page and we're just like, share this, share this, share this. And then when we were getting to that point, we decided to do a call bank to find Vanessa and to urge other elected officials to do that. And then we did training decks on how to lobby for Vanessa. And we issued those publicly. So I don't, those of you who've been on the page for a while, you would have seen that back in early months, like on our website, like phone banking sessions and stuff like that. So we were doing like our normal course of advocacy work to urge elected officials to find her and start an investigation and create awareness on her story. So then every time an article came out, we were posting it and telling everyone to share it, just doing what we could to create awareness. And then we added a missing persons ad for Vanessa in our Reflections magazine, because we had another part of our audience who buys the magazines, so they could be educated as well with what was going on. And this all happened before this story really like took off. And then in July, I flew down to Texas and I gave a speech in Houston, Texas, and San Antonio. So it was like that was all going really great. And it was like we were getting the momentum to propel the story forward. And then I was speaking with the family, and we gave them a proposal about how we thought it was best to get the legislation passed. At the time, I think they were just really overwhelmed, and they were like, we're going to go forward, in a different direction. So then at that point, I was like, okay, well, we're going to continue doing what we're doing, which is pushing Mira in Congress. And we're already at this point. We're already taking lobbying meetings anyway. But the thing was, at the back of my head, I was like, I really want this legislation, Mira, to be a part of the I Am Vanessa Guillen bill, because I know how powerful the legislation is. And, and this wasn't something we thought of overnight. This was something that was already in the works for the last 2.5 years that we've learned from the community and from survivors. Like, we created this legislation. And when all that was kind of happening, I was like, well, we're going forward with our lobbying efforts for our bills. In the back of my mind, I was like, God, if it's for the highest good and the highest purpose, I'd love to see Mira in the I Am Vanessa Guillen bill. Like, that would be ideal. That the family gets a legacy. It's a strong, solid bill. Survivors get justice. The things are changed, and now, we were part of this good fight. And that was really the like goal. I would say like the goal. However, we were focusing on Mira, but it was like this like little note I put into the universe where I was like, this would be ideal because I think it would be for the highest good, the highest purpose. Like, being able to contribute to Vanessa's legacy in the way that we are is like, it's so heartwarming. And to be able to protect the next generation, like, to be a part of this story. And for me, it was like, it hit home for me in so many ways where I was like, this is why I'm doing it. Like, this story is my purpose. And I mean, and everyone else's stories, right? Like, everyone's stories we've brought forward over the last couple years. But this one, I was like, when just a young Hispanic girl, like it brought me right back to me going through it. And I was like, no, like I want to be part of this story and I want to be part of the story to pursue justice. So that's really where um it just hits so close to home. And it's just so crazy how the beginning of this all happened with our artist who lives in the area in Houston, Texas, and how everything just kind of grew from there. And, you know, we started taking our meetings over the summer after we invested into digital interactive lobbying kits. And we started taking meetings left and right, like all day meetings is what we were doing to be able to meet with different reps in different houses to get them to sign on to pledges, to help them to maneuver this forward, to help support it. And then when the I Am Vanessa Guillen bill happened, we were already deep in these meetings. Like we were already like 7 months deep into our meetings with Congress. So the thing was like they got the statistics, they got the facts. So it was just aligning up really nice. And then you know, we took some meetings over the last couple weeks and we gave them like the final proposal and the final vision for what we wanted. And then the I Am Vanessa Guillen Act got introduced. The thing was, they didn't tell me at that point that, that our policies got put in the I Am Vanessa Guillen Act. They emailed me like a day late and then told me. So I was like, what's going on here? Because we were told our legislation's going through. So I was like, what's going on? Then we got the email and they were like, here's the bill. You review it for our next meeting. They were like, we're taking a lot of the MIRA policies and we're putting it into the I Am Vanessa Guillen Act. And then I was like, what? Like, I was like, is this serious? Like, is this serious? And then I started reading the bill and then I was like, oh my gosh, like, it was just a moment of like, a crazy moment of gratitude, feeling really humbled and just seeing the way that it manifested. I was like, holy shit. And it felt really good because it was like Mira's legacy now is so much stronger because it's Mira's making a massive contribution to the I Am Vanessa Guillen Act. And, you know, it's great because it's leaving a legacy and at the same time protecting the next generation of young people who will enter the military. So it's leaving a powerful legacy for Vanessa's family, but as well as all service members. It's a strong level of change that's needed to happen. So it's like for me to be here and our other volunteers that have been working on Mira, you know, that are now all working on the I Am Vanessa Guillen Act, it's an amazing feeling to be able to contribute in the way that really matters most. And obviously, as survivors reading this, we know what the hurdles are, you know, what those situations look like. And we're able to be like, okay, this writing is not as inclusive to some people in our community, right? And this leaves one person out, or this has a loophole here that could be harmful. So we have that insight to offer. And it's just really great to be able to turn pain into power and to be a part of something that's just so much greater than what I've ever imagined. Like, it's just such a powerful, powerful legacy to be a part of. And the fact that we get to contribute in this magnitude to change, I'm just thankful. I'm really, really thankful to everyone who has supported us in getting here, to everyone that has helped us develop to this point, and you know, the fact that we can contribute in this way. You know, this is just a massive contribution to military families, to the military community, to the veteran community, to minority communities, the Latinx community. Like, this is just such a big win, I think, for everyone across the board. And it's, you know, on the right steps to creating a more equal and just world for everyone. And that's something that I think is really important. I think the compact law is changing that. I think some of the questions that you're having, Wendy, are under the compact law. And I read over basic things for that. I have to get the actual compact law bill so I can see a lot of the changes, because there are a lot of changes getting made under that law. But that's the VA. That's not the Department of Defense. The bill we're talking about right now is getting through the Department of Defense. So the compact bill that's going through is making changes within the VA system. And that is what I think a lot of your questions are gearing towards the VA. So yeah, what I want to say to that is the Reflections magazine, the perspectives pieces that everyone's, contributed to, we delivered all of that to Congress, like all of it. So like your stories have been read and your stories have been seen. And I think that's why it also affirms some of the legislation changes that are going on. Like protected classes are getting introduced into this rule. There's different aspects of that are being included that weren't included. And that's your stories, 100%. That was your stories of you guys coming forward, because these publications, we gave them to Congress. We gave the Reflections magazine. Reflections is almost everybody in Reflections is part of the LGBTQIA community. And a lot of Reflections people talked about retaliation and talked about discrimination and racism and retaliation, right? So you see that there's a need and a trend with that. And then when you see perspectives shows the same trends, and it shows that with a lot of the minority veterans, you start seeing how their stories play out. So your stories were major contributors to be able to educate people in power about how to write these bills. And, all of these publications and everything that we've put together, it's the fact sheets to educate on the statistics of what happens during reporting, who's facing these challenges, everything like that. All of that was done by people like you in our community. We had people that stood up, wanted to get involved, and they got involved, and everyone was able to make this contribution to move the conversation forward. And like that's something that I always say is that yeah, well, this is perfect. All right, so something I always tell everyone who's a volunteer in the movement, people will ask me, they're like, oh, do you care like about your reputation? Do you care about this? I'm like, to an extent, yes. But I always tell people, like, what I care about the most is being effective. And to me, being effective is what results in change. So for me, when I'm looking at where I'm going to invest energy, and where everyone in the movement's energy should be, I'm always focused on what's effective, what steps are effective. And sometimes I feel a certain way, but my feeling doesn't match effectiveness. So I have to sit there and be like, let me process out my emotions and go back to being effective. And in this case, I knew 1000% that our policies are the most effective. So when it came down to, lobbying and doing our work, I was like, we're going to do a lot of work behind the scenes over the summer. And we're going to be taking all these congressional meetings. And, we're going to really hone in on, what we're doing with Mira. And the whole time I was like, I really hope this manifests and becomes the I Am Vanessa Guillen Act of 2020. Like, that is the best contribution. Like, it's better than what I envisioned. And I was like, this would be great. Like, just to be able to contribute to this kind of work and this kind of legacy for everyone, like that, like, so the whole time we're doing our thing over the summer, that was really a focal point. But while I wanted those things, I was like, we have to be effective. We have to have effective meetings. We have to have effective legislation, and we need to be effective at explaining this legislation and why this needs to change. So at that point, it was like, all right, let's focus on our Mira brand, focus on what we're doing, and let's, get the job done. And that's really what we did and for it to manifest our lobbying work to manifest as the I Am Vanessa Guillen bill, I like couldn't be happier. I could not be happier. It just feels like I've fulfilled my life purpose and also like the point of literally turning pain into power. Like this is the arrival point. And I'm so grateful that like I'm a Puerto Rican woman. Vanessa is Mexicana. And it's like to be able to use my life story that was so similar to hers. And now I get to be a part of getting her justice. And MST, well, all of us at MSTM, because like there's a lot of people who contributed to this. But for me personally, joining on to like this journey and being able to do this like as a Latinx woman and get to ensure that these policies and these procedures, it's like I get to help another Latinx family. And for me, like that's even more personal where I'm like, okay, we have to be on our A game in these meetings. We have to be on point in what we're doing. We have to ensure that everyone feels represented. And like that's really what we're going for when we're having these conversations. So like to be here and be at the point of like fulfillment of my life purpose, it feels amazing to be here. And it is such a humbling experience because I couldn't have thought of a better way for Mira to make a contribution. And under the I Am Vanessa Guillen Act is like the perfect way to do that. And I feel like that's so powerful. And I feel like the work that we're doing is so much more powerful than I think what any of us ever imagined. And to see it coming to life now with the work that we're doing, I'm just grateful, really grateful, you know. I'm grateful that to the universe and God for, you know, putting us in this position, for giving us this opportunity, and, you know, for the work that all of our volunteers have done, the work that we put behind this, and also just never giving up, even when times got hard. You know, we dealt with it and we got here, and now that we're here, and that we're at this place, it's nice to see how excited everyone is to be a part of this, you know. And it comes with the double-edged sword, right? You know, because when you reflect on Vanessa and her life, she's not here. So it's like her story would end with pain, but creating a legacy for her, we're changing that for her to rest in power. And that's something else that aligns so well with what we do at the movement because our slogan is turning our pain into power. And to be at that point, it's amazing to just see everything and how everything birthed and turned into this, and that we're here. And now that we're here, um, you know, we're fighting for justice. And it's an interesting road. It's had its ups and downs, but we got here, you know, we got here, and that's what matters. And now all of us right now, we're turning our pain into power. And this is the moment for that. And that's why like the bill, reading the items on it, understanding it, having discourse and a dialogue that we've been doing with you guys, the reason we've been so transparent in communicating is so that you understand what we're looking at and the conversations that we're having. So the conversations we're having with you are the conversations that we're having with Congress. So, you know, that way you know what's going on and you have an idea of this. And we've gotten feedback too that has helped with a couple of different areas. Like someone messaged earlier, like, is there a retro claims process? And, you know, we looked at the bill and I'm like, all right, that's something that we're adding on our agenda for tomorrow. So you guys have been really helpful in giving us feedback for things that you would like to see as well. So, you know, we appreciate the efforts that everyone has been making. And, you know, and also thank you for like adjusting to the COVID situation because it was like COVID was super hard to do anything in person because obviously you want to catch your elected officials if you're going to DC, but like if they're not in DC, you can't catch them. So, you know, we had to do a lot of running around to figure out what was the best way to get our work done. And then we had to readjust the whole campaign and the lobbying campaign for Mira. But what I want to tell you is, like, you guys kept us at the forefront. And not only did you keep us at the forefront, you know, you guys really made sacrifices that you guys were okay with, for the good of the whole and for us to progress, you know, this legislation. So now that we're here and now that we're really working on this, we're doing the best that we can. Like, this needs to be a very inclusive bill that protects everyone, and that is the legacy that her family deserves. Right? Like, an angel deserves the best, and that means making her life be the fight for the highest good, and the highest good for everyone, and the highest good for all of us. So we're ensuring that that bill does justice for Vanessa, and that's what we're working on. So I went over everything that we're going to pretty much go over in the meeting. There's going to be a couple more questions and topics that I think we're going to ask, but I'll bring that stuff up tomorrow. We'll do a debrief tomorrow. And you know, if you guys have any questions, just shoot them to us. I hope this answered a lot of your questions. I put that together based on the questions we got that I thought made interest to you. Because looking at bills is probably not the most interesting thing, like legal jargons. How can we help if you need help? I mean, we always could use help and volunteers. So there's a lot you can do. We do organizing calls if you want to volunteer. There's a lot of different aspects of what we do. If you direct message the movement, we can talk to you more about ways to help and maybe where to volunteer. If you want to help us in this effort, that's the best place to start, right? Because everyone wants to do different things. So that'll help us understand, you know, what you want to do and how you want to help. There you go. Send a message to the page or go on the website and fill out the volunteer form. They're always accepting volunteers. This is true. Yeah, I mean, I'm happy to see all your comments that you guys are really happy about this. There's just so many. Yeah, we answered everyone's questions on here for the night. If you have more questions, feel free to direct message us. The rest of the night, we're just putting the rest of our recommendations together, and we're sending them out to Congress tonight, so we could be prepared for the meeting tomorrow morning. So, you know, we'll give you a debrief sometime after. I don't know what time after, but you'll hear from us. On that, you guys have a good night. I'm going to continue working, and then we'll reconnect tomorrow, so you'll have another brief. All right, take care.